Chapter 4, Pretrial Activities, Interviewing, Negotiation, and Discovery. Introduction. Attorneys who work for the Child Support Enforcement Program can perform their jobs most efficiently when they share the responsibility for information gathering and case preparation with other program personnel. The relatively routine nature of information gathering and case preparation allows non-attorney personnel to perform many investigative functions, and even some of the decision-making function. The same is often true for the routine negotiation of arrearage settlements and current support amounts. Nevertheless, some evidence gathering involves legal mechanisms that require an attorney. In complicated cases, especially those involving contested paternity, the attorney must interview the custodial relative and other potential witnesses, and negotiate with the absent or alleged parent, or his or her attorney. This chapter discusses these activities within the context of the program. Interviewing witnesses. The extent to which an attorney becomes involved in the interviewing process in any case depends on the complexity of the case, the structure and policies of the state and local programs, and procedural alternatives afforded by state law. In pure enforcement cases which do not necessarily involve a court hearing, for example, garnishment in a state that has a summary post-judgment execution procedure, the attorney commonly relies on the information gathered by a child support caseworker. Generally, no communication occurs between the attorney and the custodial relative in such a case. In enforcement cases which require simple court hearings, it is common practice for the attorney and the custodial relative to meet briefly, often immediately preceding the hearing, simply to review the information gathered by the child support worker and to prepare the custodial witness to testify. Again, the attorney delegates most of the interviewing and investigation to the caseworker. The attorney is much more likely to do a significant amount of interviewing in cases which require the establishment of paternity and/or the entry of a current support order. Court hearings in such cases are more complicated, and the attorney must depend on live testimony to establish the identity of the alleged father and/or the needs of the children. In order to prepare properly for such hearings, the attorney must evaluate the knowledge and verbal skills of potential witnesses. Interviews also provide an opportunity for the attorney to develop rapport with the custodial parent. The most successful interviews occur when both the interviewer and interviewee are relaxed. Unfortunately, child support interviews take place in an atmosphere that is inherently stressful simply because of the issues which must be addressed. Two factors can help the interviewer be more comfortable with the interviewing process: experience and skill. This section discusses skills and techniques that can make interviews more comfortable and improve the likelihood that they will produce valuable information for the attorney to use in deciding what claims to make or remedies to employ. Preparing for the interview. Busy child support enforcement attorneys often view planning for interviews as a time-consuming and unnecessary exercise. This is an unfortunate misconception. A well-planned interview will be more successful and less time-consuming than one that has not been planned. Preparation instills greater self-confidence in the attorney, interviewer, leading to less anxiety for both parties and less irrelevant discussion. The planning process varies with the nature of the case, the extent of investigation that has been conducted by other program personnel, and the interviewee's familiarity with the program's purposes and policies. There are several basic areas that should be considered when planning any witness interview: reviewing case information, identifying interview objectives, preparing necessary legal documents, setting the stage. Reviewing case information. The attorney should spend several minutes reviewing the case file prior to interviewing custodial relatives or other witnesses. If the review occurs far enough in advance of the interview, the interviewee can be contacted and asked to bring in any documents missing from the file or relevant to the coming court hearing. Since interviewing may occur at several different points in the process of establishing or enforcing a child support obligation, the amount of information and documentation contained in the case file will vary from one case to the next. Most child support agencies use a case activity form, or case action log, which provides a chronological listing of all actions, correspondence, and communications pertaining to a particular case. This document is an excellent starting point in the review process. It chronicles the history of the case and often provides some insight into the issues that the absent parent will raise in defense. The objective of the review is to become familiar enough with the facts of the case to determine who should be interviewed, to formulate interview objectives, and to identify information that should be gathered and legal documents which need to be prepared prior to the interview. Identifying interview objectives. After the review is complete, the attorney should formulate a list of objectives to use as a guideline for conducting the interview. Clear objectives help identify subject areas which need to be explored and the proper tone for the interview. The optimal tone differs from one interview to the next, depending on the identity of the interviewee and the subject to be explored. For instance, if the case review indicates that the custodial relative has been less than cooperative, the tone of the interview may be crucial to a successful outcome. The interview properly begins with a supportive and persuasive argument for cooperation. Should that approach prove unsuccessful, a terse statement of potential sanctions, coupled with a reminder that a subpoena is an option, might cause a change in attitude. In any event, the attorney should explain his or her role in the program and give some background on its procedures and benefits. Such an approach strives to establish rapport and to explain fully the limits of the relationship between the program attorney and the custodial relative. In addition to establishing rapport and gathering information, other possible interview objectives include testing the interviewee's credibility as a witness and ability to hold up under an abusive cross-examination, exploring the possibility of fraud, identifying potential defenses, preparing the witness to testify in court, and identifying and locating other potential witnesses, preparing necessary legal documents. In many states, the custodial relative verifies the allegations of initial pleadings or prepares supporting affidavits. In interstate cases, the custodial relative must prepare a testimony form and/or an arrearage affidavit. Experience has shown that obtaining these documents from AFDC recipients can be a difficult task. To minimize the problem, the attorney should have pleadings ready for signature during the interview itself, and determine during the interview if additional documents need to be prepared and executed. If that is the case, the attorney, or an assistant, can help the custodial relative and obtain a signature while he or she is in the office. Setting the stage. Child support and paternity interviews can create a high degree of discomfort for custodial relatives and other witnesses due to the sensitive and personal nature of the subjects which must be discussed. The physical setting of the interview can increase or decrease such anxiety. The attorney should do what he or she can to provide a setting that is conducive to professional attentiveness, quiet ease, and privacy. Another important variable is the physical proximity between the interviewee and the attorney. In private practice, attorneys typically conduct client interviews from behind a desk. Such a practice is well suited to a situation in which the attorney is trying to impress a potential client with his or her professional demeanor. It may not be appropriate in the usual 4D context. First, unless the attorney has a private office with a door, it may be difficult to ensure a sufficient degree of privacy if the attorney and interviewee are separated by a desk. Second, the custodial relative must perceive the attorney as an ally, as opposed to a representative of the establishment who is there to do something to, not for, the custodial relative and the children. The desk creates a barrier and turns the attorney into an authority figure. This dynamic can be avoided by placing the interviewee at the edge of the desk instead of the opposite side, or by moving the interview to a table and sitting next to the interviewee. In their two-part article entitled, The Art of Interviewing and Counseling, Mark K. Cernfeld and Barbara Perlman Cernfeld suggest the following additional tips for designing successful interview settings. Place the interviewee in view of the door, if possible, to lessen his or her feeling of being trapped. Try to avoid making the interviewee wait for the interview to begin, to lessen the opportunity for tension and anxiety to develop. Cancel all telephone calls and ask not to be disturbed. 0. Try to use an office with soft, natural lighting to minimize the connotation of interrogation. Do not discuss matters relevant to the case in the presence of third parties. Conducting the interview or opening the interview. For interviews with a custodial relative, it is particularly important to establish rapport as soon as possible. There are several ways to do this. Employ normal ice-breaking techniques, that is, spend a minute or two making pleasantries. Spend some time early in the interview, perhaps as a transition between the pleasantries and the bulk of the interview, asking the interviewee positive questions about his or her background, This increases the interviewee's self-esteem and personalizes the interview. Inform the interviewee of the status of the case and the attorney's role in the matter. Try to project empathy for the interviewee's situation within your role as professional legal representative of the 4D agency. Neither expect nor demand the immediate confidence of the interviewee. Acknowledge his or her anxiety to discuss intimate details and deal with that anxiety in the open by stressing the laudatory goals you are trying to reach together. Conducting the interview. One of the dangers of working in a very specialized area of the law is that every case can begin to look alike, so much so that one begins stereotyping cases prior to completion of the fact-gathering process. Such a practice inhibits successful interviewing in at least two respects. First, it tends to close off potential areas of inquiry. The interviewer fills in factual gaps with assumptions based on his or her experiences with other cases, instead of pursuing information from the interviewee. The interviewer may even miss unanticipated answers. Second, and perhaps worse, the interviewer unwittingly may transfer his or her attitude to the interviewee, producing a self-fulfilling set of facts. To avoid these problems, the Sernfelds suggest minimizing the formal structure of the interview, keeping a mental agenda in lieu of a written one, and being willing to deviate from the agenda and explore as new information unfolds. A set of prepared questions for use on all cases would run contrary to this approach and make it difficult to follow up on unusual things said and unsaid. It is a good idea to let the interviewee explain his or her perception of the relevant facts prior to asking specific questions. This technique minimizes the structure of the initial part of the interview, allows the interviewer to give supporting verbal and nonverbal feedback without affecting the subjects chosen by the interviewee, avoids an atmosphere of interrogation, and allows the interviewer to assess the interviewee's value as a witness. If the interviewee is reluctant to talk, initiate the conversation with questions that call for narration. Avoid ones that lead to unclear answers or subject areas. After the initial narration, check and probe with gentle but direct questioning. Avoid rehashing the story chronologically. Rather, broaden the picture by grouping facts by related topics, both those topics brought up by the interviewee and those that you may have constructed as the interviewee discussed or failed to discuss relevant issues. This technique forces the interviewer to be creative and explore uncharted factual areas. It is also very effective for disclosing fabrications. If the interviewee has a difficult time discussing the facts in any order other than the one he or she chose the first time through, the attorney should be wary of the story. Taking notes. Note-taking is a necessary part of the interviewing process, but it can undermine effective communication. An interviewer who takes notes frequently during an interview adversely affects the process in at least two important respects. First, the interviewer must break eye contact with the interviewee. Second, the mere act of noting a fact creates a perception in the interviewee that this fact is comparatively more important than facts not noted. As a result, the interviewee may react by concentrating on areas which he or she perceives to be legally relevant, instead of allowing the attorney to control the interview. These problems can be minimized by adopting the following techniques. As suggested above, allow the interviewee first to relate the whole story unimpeded, directing him or her only with questions which call for open-ended, narrative responses. This has the additional advantage of allowing the attorney to evaluate the interviewee's mental state and value as a witness. Next, lead him or her back through the story a second time with structured questions, sequenced according to logic and legal relevance, while taking constant notes, using keywords only in the notes in lieu of complete thoughts. Maintain as much eye contact as possible. After completion of the second run through, refer to the notes and politely cross-examine the interviewee, testing his or her memory and credibility, and following up on leads. Immediately after the interview, convert the notes into a memorandum to the legal file, fleshing out the condensed material and adding impressions. Posing questions and responses. The question and answer portion of the interview should maintain and deepen the rapport developed with the interviewee during the early part of the interview, as well as provide additional information. The following techniques are useful. Use standard English. Avoid legal or program jargon and street lingo. The former is confusing and the latter may be perceived as condescending or unprofessional. Should the interviewee get off the track, redirect gently, Avoid critical remarks which may cause the interviewee to censor the story to conform to what he or she perceives as your agenda. Encourage responses with verbal and nonverbal feedback. Avoid seeming judgmental. Do not inhibit the interviewee's responses by reacting negatively to unusual or aberrant behavior. Do not fear silence. Give the interviewee an opportunity to think about his or her responses. Employ the funnel approach. That is, move from the general to the specific. This approach promotes free association and triggers the interviewee's memory. Clarify and encourage continued discussion by periodically restating, elaborating, or condensing previous statements or impressions made by the interviewee, but take care not to make the interviewee feel inarticulate in the process. Be skeptical, especially where the story is unlikely, but transfer your disbelief to the judge, jury, or opposing counsel. Approach intimate details with care. Be neither profane nor prudish. Avoid multiple questions and questions which contain double negatives. Closing the interview. When the attorney senses that he or she has gathered all the information that is to be gained in the interview, he or she should summarize briefly what has been accomplished and what will happen as a result. The summary and explanation provide a smooth transition to departure, facilitate understanding, and increase rapport by demonstrating that the attorney cares about the interviewee's perception of what has transpired and what will occur next. This can be underscored further by asking the interviewee if he or she has any questions. If the interviewee is to execute any legal documents or provide any additional information, the attorney should refer to that fact and provide specific instructions. If it is office policy to provide copies of all correspondence and legal documents to custodial relatives, make such a pledge during the close of the interview. Encourage the custodial relative to supply additional information pertaining to the case and set out a specific procedures for providing such information. Do not encourage additional direct contacts by reminding the custodial relative how busy attorneys are and how difficult it is to work on any individual case when parents want continual conferences with the attorney. Preparing witnesses to testify. It is important to spend a few minutes instructing all witnesses how to approach giving testimony. Such instruction is particularly important for witnesses in child support cases because they often have had little exposure to the courtroom other than the dramatic portrayals of television and the movies. The following suggestions should be helpful. Furnish witnesses with the questions in advance, or go over them orally. This process is for the benefit of the attorney as much as the witness. Warn the witness that cross-examiners often ask whether the witness has discussed his or her testimony in advance of taking the stand, hoping to elicit an equivocal response and some guilty-looking body language from the witness. A good response is, of course, advise the witness to refrain from volunteering information not asked for by the questioner, and just answer the question. Advise the witness to admit not knowing the answer to any question. This is particularly important in paternity cases regarding the exact date of conception or the last menstrual period prior to conception. An answer that is too exact may seem fabricated and give opposing counsel ammunition to destroy plaintiff's version of the facts. Give the same advice regarding the witness's memory, but add the warning that a selective memory, forgetting only facts that may be harmful, can destroy a witness' credibility. Advise the witness to speak loudly with good projection, especially in jury trials. A good way to check on volume and projection is to begin examining the witness from the point most directly in front of the most distant juror. Advise the witness to refrain from responding to hostile cross-examination with sarcasm. The judge or jury will respond more favorably to a soft answer that contrasts with the hostility of the question. Advise the witness to avoid the temptation of responding to a question with a question. It only produces an embarrassing instruction from the judge. Encourage the witness to think out his or her answers before responding. A brief pause helps compose the witness and gives the attorney an opportunity to make an objection. Give the witness a crash course on the hearsay rule, and warn him or her to refrain from discussing what someone, other than a party to the suit, said. Advise the witness to refrain from couching his or her testimony in the form of opinion, unless the question clearly calls for it. Spend a great deal of time instructing the witness about dress and demeanor. Conservative dress, hairstyle, and adornment are essential. especially in paternity jury trials. Ask the witness to turn slightly toward the judge or jury when answering questions in order to make some eye contact and develop rapport. Advise the witness to avoid attempts at humor. The only type of humor that works in a courtroom is the unintended variety. Advise the witness to refrain from losing his or her temper in the face of antagonistic cross-examination. Other emotion, such as sobbing or crying by female witnesses, is probably not harmful as long as it appears genuine. Advise the witness to stop talking when an objection made. Negotiation. The first section of this chapter dealt with interviewing favorable witnesses. This section turns to contacts with the absent parent, or his or her attorney. Most contacts of this type are aimed at reaching a negotiated settlement or consent agreement. Negotiated settlements are preferable to judicial resolutions, especially in areas of the law such as child support enforcement, where the expenses of litigation for any individual case are significantly greater than any expected monetary recovery. From the 4D agency's perspective, virtually every case litigated in the traditional court system is probably not cost-effective. Litigating child support cases cost the agency, and society in general, to the extent that court time and personnel are involved. The time and effort spent preparing for court and attending a hearing are time and effort which could be spent on more cost-effective activities. Perhaps more important than the short-term cost is the long-term effect of judicial resolutions. Common sense suggests that absent parents more often comply voluntarily with consent orders than with orders imposed after contested judicial hearings. Negotiated settlements are clearly more conducive to maintaining a peaceful relationship between parents, which is important to the continued growth and development of the child. Preparing to negotiate. Contacts with absent parents that involve negotiation are in many ways similar to the interviews discussed above, because gathering information is an ancillary goal of each negotiation session, and because many of the interpersonal dynamics are similar to those discussed above. It pays to prepare for a negotiation session as you might prepare for a more routine interview. Review case information. To design a workable settlement, one which both parties prefer to litigation, it is necessary to have information. A negotiator needs information about the needs and objectives of the 4D agency, the custodial relative, and the absent parent. Indeed, one of the main strategies of negotiation theory concerns the willingness with which the negotiator divulges information about himself or herself, or about the client he or she represents. The case file thus becomes a valuable asset to the skilled negotiator, one which should be consulted well in advance of a negotiation session. Clearly, financial and employment information about the absent parent is relevant to the amount of support he or she should be required to pay. A well-developed case file often will contain more than this. For instance, the narrative section of the file may document the concerns the absent parent has expressed during previous contacts with the agency. Such concerns occasionally can become concessions in the negotiation process. The narrative section also can be a good source of information regarding the absent parent's present living arrangements, which may indicate an aversion to publicity that can strengthen the agency's bargaining position. The same is true of file information regarding the custodial relative and the children. The case file should reflect any special needs which might be met by tailoring the support obligation. The ages of the children are clearly of some relevance in designing the terms of the order. If an action has already been filed and the matter assigned to a specific judge, that information is clearly relevant to the range of acceptable settlements. Judges establish patterns over time, and an attorney should take these into account prior to accepting or rejecting any proposed settlement. Identify objectives. A negotiator should enter a negotiation session with a number of objectives. Frequently, within the context of the child support enforcement program, they will including the following: obtain adequate current support, establish paternity, obtain blood test stipulation, close the AFDC case, obtain additional information to be used during enforcement, obtain income assignment, effective immediately, establish and maintain a working relationship with the absent parent, avoid using valuable court time. Generally, the client sets these negotiation objectives. At this point, the 4D attorney should limit his or her role to providing advice and counsel. It is tempting to appropriate decision-making authority and set the negotiation limits. Avoid this temptation. treat the agency like a private client and allow authorized individuals to set the ground rules. Thus, prior to conducting any negotiations on behalf of the 4D agency, the attorney may want to meet with authorized representatives of the agency to set general negotiation strategies and establish the limits of the attorney's authority. Prepare necessary legal documents. Many child support enforcement legal units have standardized legal documents for all negotiation sessions. Standard forms allow the attorney to reach an agreement with the absent parent and prepare documentation all in one motion. Even where a consent agreement cannot be reached, the attorney may be able to obtain a waiver of service of process from the absent parent, who generally wants to avoid a visit from the sheriff. Negotiation strategies. Negotiation is a process in which parties with differing interests seek a mutually agreeable set of terms that each would prefer to non-settlement. Traditionally, the process has been an adversarial or competitive one, with each side trying to mislead their other about his or her true settlement range, while discovering the true range of the adversary. The traditional strategy produces a number of non-productive behaviors and, therefore, may not be appropriate to child support enforcement negotiation. Many writers now are identifying an alternative to the traditional strategy, variously referred to as problem-solving, collaborative, principled, on win-win negotiating. These approaches are discussed below, both in theory and in the child support context. Traditional strategy. The traditional negotiation model is labeled positional or competitive. It involves submitting an initial position well in excess of the negotiator's point of minimum resistance, strictly adhering to this position, restricting the flow of information about the negotiator's fact situation, attempting to obtain the opposition's facts without giving up much in exchange, and discounting the importance of the continuing relationship between the negotiators in exchange for short-term gains. Selecting an initial position. In the normal legal negotiation, the choice of an initial position is of utmost importance. It is an attorney's first opportunity to convey his or her client's position to the opposing counsel, and, if conveyed in the form of a pleading, it may limit the amount of the ultimate recovery. The initial position also says much about the client's commitment to litigate the matter should negotiation fail, his or her willingness to negotiate and the range in which such negotiation is likely to occur, and the attorney's experience or naivete in estimating the value of a claim. In the child support enforcement context, federal regulation often dictates the initial position. For instance, in a paternity case, there is little negotiating headroom on the issue of paternity establishment, since there is no court order. The amount of current support to be sought is calculated with a formula for determining support obligations as required by 45 CFR 302.53. Nevertheless, there may be some decisions to be made as to the amount of any claim allowed by state law for reimbursement for support paid by the custodial relative or the welfare agency in the past. Agency policy may dictate the choice here as well. Adhering to the initial position. A fundamental precept of the traditional negotiation model is to avoid making concessions, especially the initial concession. By adhering to an initial position, which is at or near the opponent's minimum settlement position, the point at which the opponent would prefer litigation to settlement, the negotiator theoretically gains several advantages. First, the opponent gains respect for the client's position and the negotiator's toughness, and is therefore more likely to make significant concessions. Second, the delay improves the negotiator's opportunity to gain information with which to gauge the opponent's commitment to his or her opening position and willingness to litigate. Third, by adhering to the initial position, the negotiator increases the favorableness of any split, the difference resolution. Traditional negotiators employ several techniques to justify strict adherence to their initial position while keeping the door to negotiation open. One technique is commitment and consists simply of statements intended to convince the opponent of the sincerity with which the negotiator intends to adhere to the initial position. The commitment can be communicated in the form of a pledge of resources, a reference to a moral principle, or an interest in maintaining a reputation. In the child support context, most opponents probably assume a pledge of resources. Once the 4D legal unit has begun to process a case, it usually is understood that the matter will go to trial after an unsuccessful negotiation. References to moral principles often involve allusion to the mission of the program, the directives contained in the federal regulations and state statutes, and societal mores concerning the child support obligation. The reputation issue can be injected by letting the opponent know that the negotiator is keenly aware of the importance of maintaining a tough legal reputation regarding the enforcement of child support obligations and the effect of the immediate case on that reputation. Another such tactic, rationalization, includes any argument intended to convince the opponent that the negotiator's position is based on principles which both parties share and which are rooted in predominant social values. This is a common tactic in child support negotiations, given the strong moral nature of the obligation. Another example is the use of objective support guidelines, as urged by the Child Support Enforcement Amendments of 1984. Guidelines must be established by October 1, 1987, to back an initial position regarding how much an absent parent should be required to pay. Still another adherence technique is the threat. Threats are used to change the opponent's expectations of reactions his choices will elicit. The basic motive here is to convince the opponent that the costs of failed negotiation are greater than he or she initially estimated. In the child support context, a threat could be a reminder that failure to reach an agreement on arrearage repayment could result in a contempt hearing before a particularly tough judge. Another example would be the statement, if true, that all contested paternity cases which go to trial include a reimbursement claim, in addition to the paternity and current support claims, and that the court has a history of granting such claims. In a few states, such a claim can apply in an action to establish a support obligation as well as in the paternity situation. Threats to file a criminal non-support action should the negotiation fail are clearly unethical. Controlling and limiting the flow of information. In his article entitled A General Theory of Negotiation Process, Strategy, and Behavior, Professor Gary Lowenthal notes that the chief problem with adhering to a position at or near the opponent's minimum point of settlement is that, typically, the negotiator enters the negotiation process without any knowledge of what that point is. As a result, one of the traditional negotiator's most important objectives is to control the flow of information to and from the opponent in order to discover that point without revealing his or her own. This objective and the techniques discussed above, commitments, rationalizations, and threats, combine to limit the exchange of true information. Information exchange can be restricted in several ways, all of which involve some form of concealment or deception. One of the most common forms of this behavior involves false commitments by the traditional negotiator, which then are bargained away in exchange for information regarding the opponent's minimum point of settlement, or some other form of concession. In the child support context, the false concession could be the reimbursement claim. In exchange for some good financial information, such as the absent parent's tax returns from the previous 3 years, the 4D agency could release its claim for reimbursement of amounts expended in public assistance prior to the establishment of the current support obligation. Prior to the release, the agency negotiator would be acting as though the reimbursement claim is of paramount concern. Another technique popular with traditional negotiators is to feign limited authority to speak, or make concessions, on behalf of the client. This can be achieved by painting the client as a very committed individual or organization, by overstating the difficulty the negotiator will face in communicating any settlement offers, and by stating that another attorney reviews all settlement offers prior to their submission to the client. All of these techniques have the goal of causing the opponent to divulge information, perhaps in the form of a settlement offer, without the need for a concession or binding agreement in exchange. In the 4D context, the negotiator could state that all offers of settlement must be approved by the district attorney, or some high official in the 4D agency, who is described as a very tough negotiator. The same reputation could be drawn for the judge who would have to review any order which is entered or arrearage settlement which is proposed. Minimizing the importance of a continuing relationship. The traditional negotiator typically maintains an adversarial attitude and acts as though the relationship between the negotiators, or the parties they represent, is irrelevant to the manner in which the negotiation is carried out. Such behavior may be used to convince the opponent that the negotiator is tough and committed to the initial position, or to take advantage of an opponent's perceived desire to walk away from the negotiation table with the relationship intact. In the child support enforcement context, Such behavior sometimes is used to impress upon the absent parent that his or her excuses for non-payment, or reasons for non-liability, are so invalid that they are not even worthy of serious discussion. Collaborative strategy. In recent years, many writers have identified a workable alternative to the traditional negotiation strategy. The most popular and comprehensive treatment of the new negotiation strategy, which is referred to as collaborative negotiating in this handbook, is Fisher & A's bestseller, Getting to Yes. Fisher & A note that the traditional negotiation strategy is inefficient, produces unwise agreements, and endangers the ongoing relationship of the negotiators, because both the initial positions and subsequent settlements are often wholly unrelated to the true interests of the respective parties. To avoid these disadvantages, Fisher & A have identified several techniques, which are briefly discussed below. Focus on interest, not positions. Collaborative negotiation strategy avoids stating positions. The parties' underlying interests define the problem, and to state a position which is near to the opposition's minimum settlement point, as the traditional strategist would propose, merely masks these true interests while ignoring those issues over which the two parties share some ground. To avoid the pitfalls of positional negotiation, collaborative negotiators begin by discussing the areas of common ground, and then turn to defining both parties' underlying interests. An important objective of the process is to define each interest from the perspective of the interested party and then to state the interest in the most specific terms possible from the perspective of that party. In order to achieve this objective, all parties must recognize the legitimacy of opposing interests. Once this process is complete, the issues for negotiation should be stated in complete and specific terms. Invent options for mutual gain. Assuming the above process has been completed successfully, the task which remains is to construct a resolution which addresses all legitimate concerns of the parties. In the collaborative approach, both sides in the dispute look for creative solutions to achieve a complete resolution. Thus, both parties must accept that the problems of either side are actually the problems of both sides in the negotiation process, and that there are no barriers, other than artificial ones constructed by the parties themselves, which prevent the expansion of the negotiation agenda to allow for creative solutions that at first may appear unrelated to the issue at hand. This creative process separates inventing from deciding. Parties should brainstorm proposed solutions without committing to them as settlement proposals. For this creative exercise to occur, both sides must be committed to a free and open exchange of truthful information. The emotional arguments that traditional negotiators employ to justify their initial positions are replaced in the collaborative approach by rational, true statements that identify problems and interests and explain proposed solutions. Insist on using objective criteria to avoid taking positions and developing the often concomitant ego attachment. Collaborative negotiators base proposed resolutions on objective criteria whenever possible. Fisher & A identify 3 basic points to remember in discussing the use of objective criteria with the other side. Frame each issue as a joint search for objective criteria. Reason, and be open to reason, as to which standards are most appropriate and how they should be applied. Never yield to pressure, only to principle. To avoid the necessity of taking a position, both parties first should agree on jointly held principles and then choose appropriate objective criteria or standards. In the child support context, the absent parent generally will agree that parents should support their children, and that parents in similar financial situations should be called upon to contribute a similar amount, all other things being the same. A paternity situation might begin with the alleged father agreeing that children born out of wedlock deserve support from their parents as much as children born of a marriage, and that authorities should seek all available evidence to determine whether the respondent in a paternity suit is actually the father of the child in question. Once the general principle is agreed on, an objective manifestation of the principle must be chosen. Where both parties to the negotiation are familiar with such an objective standard, it is not difficult to make the choice. Where one side is considerably more comfortable with a published standard than the other, the party who proposes the standard must demonstrate that the standard represents the principle that has already been agreed on. In negotiating a child support obligation amount, Reference to any support guidelines or formulas within the jurisdiction could easily dispose of this issue. Although they need not be binding, all states must have guidelines for determining support amounts in effect by October 1, 1987. This should ease the negotiations process even further. However, if no such standard exists at this time, the 4D attorney could use his or her access to court records and experience with the judges in the jurisdiction to compile a guideline. For paternity cases, the office must have material available to educate both opposing counsel and unrepresented parties regarding the usefulness and objectivity of genetic testing. Objective criteria are fair in the great majority of cases, but there may be situations in which support guidelines and genetic test results are inconclusive or even unjust. Fisher and I suggest that the collaborative negotiator remain open to adjustments that are consistent with the underlying principle. To do otherwise turns the criteria into ammunition for an argument in support of a position arrived at objectively. Such a technique clearly opposes the basic rule of collaborative negotiation, which is to avoid taking positions. The last of the 3 points listed above cautions the collaborative negotiator never to yield to pressure. To apply this rule, always ask an opposing negotiator to explain a proposed settlement in terms of theory, and let the opposition know that only principled solutions are open to discussion. In the child support context, the opposition rarely will have enough leverage to apply any real pressure. Nevertheless, the attorney should remember that this rule is reciprocal. The collaborative negotiator does not apply pressure in order to force a settlement, unless and until it becomes apparent that a problem-solving approach simply is not going to work. Separate the people from the problem. Traditional negotiation strategy downplays the importance of the long-term relationship of the parties and the negotiators themselves. Collaborative negotiation develops a positive relationship as a goal of the negotiation itself. Negotiators are people first with basic needs and wants. This is relevant to every negotiation situation, and the collaborative negotiator takes advantage of the phenomenon instead of being blocked by it. Fisher and Day list several techniques for maintaining a positive relationship despite difficult disputes. Put yourself in the opponent's shoes. Do not put the worst interpretation on everything the opponent says. Do not blame the opponent for your problems. Discuss each other's perceptions. Look for opportunities to act inconsistently with the opponent's perceptions. Give the opponent a stake in the outcome by making sure he or she participates in developing the resolution. Make sure the resolution allows the opponent to save face. That is, make all proposals in terms that are consistent with the opponent's legitimate values. Make emotions explicit and acknowledge them as legitimate. Allow the opponent to vent frustration. Listen actively and acknowledge what the opponent says. Speak about yourself, not about the opponent. Discuss the future, not the past. In the child support context, building a positive relationship with the absent parent is of absolute importance. From the state's perspective, it is important that the absent parent exit the negotiation process with the feeling that justice has been served and that the established obligation is a fair one. Any other result gives the absent parent a rationalization for non-compliance and greatly diminishes the likelihood of voluntary payment. From the children's point of view, any result which interferes with the relationship between the parents may damage a child's emotional growth and development, not to mention economic security. Choosing a negotiation strategy. Professor Lowenthal has identified several factors which affect the choice of a strategy in any given negotiation situation, including the payoff structure, the size of the agenda, the expectations and sophistication of the opponent, ethical considerations, legal constraints, and the importance of continuing a friendly relationship. As the discussion below points out, these factors affect each case differently, such that while a collaborative approach is generally more appropriate for child support negotiators, some cases require the traditional approach. The payoff structure. The nature of the underlying dispute is relevant to the choice of negotiation strategy in at least two respects. The most relevant concern is whether the two parties must share or barter the item being negotiated, or whether there exists a resolution which allows each party to increase his or her share of the outcome. A zero-sum negotiation is one in which there is one item or sum which must be rationed, such that one party's gain is offset by a corresponding loss suffered by the other party, plus x equals 0. All other things being equal, The traditional negotiation strategy generally works best in zero-sum situations. The range of solutions is so limited that the objectives of the two sides are, by definition, antagonistic. Conversely, where two parties both bring something of value to the negotiation table, and where both are willing to contribute that thing of value in a cooperative effort, the collaborative negotiation strategy is more appropriate. A good example of the latter negotiation is a partnership agreement in which, presumably, both parties benefit. Lowenthal points out that many situations appear to be purely zero-sum while possessing a sufficient number of non-zero-sum characteristics to make a collaborative approach appropriate. One good example of such a situation is a child support rearage dispute. Clearly, any amount collected by one party will produce a counteracting loss by the other. Nevertheless, the collaborative approach may be appropriate when a significant amount of arrearage clearly exists whichever negotiator's side of the law or the facts is accepted, and where it is possible to expand the agenda to address additional interests of the absent parent. For instance, assume the absent parent is admitting to a $1,000 arrearage and the 4D agency records indicate that the amount owed is $1,750. Both parties might prefer litigating the dispute over splitting the difference. A collaborative negotiator might seek to determine if any alternative interests could be served along with the settlement as to amount. For instance, the 4D agency might be very willing to settle for a $1,200 settlement in exchange for an immediate wage assignment, which will guarantee future compliance. Knowing that automatic wage withholding is mandatory under federal regulation, 45 CFR 303.100, the absent parent might be willing to settle on an arrearage figure of $1,500 in exchange for a gradual payback arrangement. The size of the negotiation agenda. As the above discussion indicates, the greater number of items on the negotiation agenda, the greater the opportunity for collaborative negotiation, even though each of the individual items would produce a zero-sum condition were they negotiated separately. Even with a traditional approach, it can be advantageous to expand the number of items to be negotiated because such expansion allows a stronger initial position. The traditional negotiator will attempt to expand the number of items within his or her initial position, whereas the collaborative negotiator will search for additional interests, from the perspective of both sides, in order to expand the negotiation agenda and stimulate the creativity of both negotiators. The child support and paternity contexts provide few ways to expand the agenda. Most available techniques involve increasing the number of claims against the absent parent in addition to the child support or arrearage claim. For instance, the following additional claims can be added to a support claim in many states: interest, attorney's fees, court costs, reimbursement of AFTC payments made to the family during periods in which no court order was in effect, lien, performance bond, or other guarantees, medical support, wage withholding, which is mandatory and effective immediately when the support order is entered, blood testing and expert witness fees. Clearly, this agenda expansion is more appropriate to the traditional approach and involves some danger of frightening the absent parent or alleged father out of any willingness to negotiate. If such problems can be avoided, the addition of ancillary claims allows the 4D agency plenty of room to give ground and the opportunity to take a collaborative approach. In addition, it is possible to expand the agenda in a few respects to meet absent parents' objectives. Some jurisdictions may want to put up the money for blood tests to assure an alleged father that he is actually the biological father. Others may be willing to contact an uncooperative employer in order to help the absent parent implement a wage assignment. Still others may go so far as to mediate a visitation dispute. Any step that secures a negotiated settlement, and is comparatively more cost-effective to the 4D agency than a contested court hearing, is a possible agenda item and should be considered and discussed. The expectations and sophistication of the opponent. Attorney's willingness to negotiate varies from jurisdiction to jurisdiction for a number of reasons. In jurisdictions where there is difficulty obtaining court time, where the judiciary is very settlement-oriented, or where seeking settlement through mediation is a required prerequisite to suit, settlement may be the paramount goal in representing a client. Where attorneys are comfortable with negotiation as a norm, it is more likely that a collaborative approach would be effective. In such a jurisdiction, it is less likely that an opposing counsel would perceive an offer of collaboration as a sign of weakness. Conversely, it is unwise to use a collaborative approach to negotiate with an opposing counsel who has a reputation for being an unshakable traditional negotiator. As a rule, the child support enforcement attorney has a considerable degree of leverage based on the resources from which he or she has to draw, and the strong public policy behind the cause. While collaborative negotiation may be a better approach in general, individual opponents' behavior may demand an adversarial approach. Similarly, some situations may call for the collaborative approach. Every attorney has an ethical responsibility to treat unrepresented opponents differently from those who have counsel. This responsibility is more pronounced when the attorney represents the government against a private citizen. The traditional negotiator may use factual misrepresentations to justify and maintain a position, and the fairness of settlement terms is of very little concern, as long as the negotiator's client is satisfied. Where the government is one of the parties, such tactics are indefensible. The 4D attorney who deals with unrepresented absent parents and alleged fathers on a regular basis may want to choose a collaborative approach. Ethical considerations. Many of the ethical considerations discussed in Chapter 3 affect the attorney's choice of a negotiation strategy. The 4D attorneys need to communicate settlement offers to his or her client, combined with the difficulty he or she may have in communicating them, may make the traditional approach easy to implement. Similarly, the 4D attorney's responsibility to refrain from divulging information relating to the representation of a custodial parent, made more stringent by 45 CFR 303.21, may limit the attorney's ability to share information with the absent parent's counsel. As noted above, since information sharing is important in the collaborative approach, that approach may be difficult to use in some cases. Other ethical considerations make the collaborative approach more appropriate for negotiating child support and paternity disputes. The special responsibilities of a prosecutor and the government attorney's extra responsibility to refrain from making even slight intentional misstatements of fact both suggest a collaborative approach. This approach may be more appropriate due to the large number of unrepresented absent parents. 4D attorneys must negotiate within the extensive explanation these negotiations require. Statutes and regulations. The Social Security Act requires each state to have in effect a plan to establish paternity and to establish and enforce support obligations for both groups of the recipient population. The statutory responsibilities have clear implications for negotiating child support and paternity awards, and do affect the choice of style. In requiring paternity to be established, the Act would seem to rule out any settlement which would allow the court to enter a support order without making a determination of paternity, a compromise allowed in some civil paternity statutes. More specifically, 45 CFR 302.53 and 302.56, which require each state to develop a formula to use in determining how much an absent parent should pay, clearly prohibit the entering of an abnormally low support amount merely to dispose of a case. Likewise, local statutes or rules can affect the process. Some judges actively promote litigants to attempt settlement before requesting court time. A number of jurisdictions have given some structure to the process by appointing masters or referees to promote settlement. The Uniform Parentage Act normalizes this practice by requiring the parties in a paternity action to attend a preliminary hearing, present their sides of the case, and allow the court to make a recommendation at the pretrial stage. At a minimum, most courts review all child support and paternity settlements to prevent the entry of unreasonable consent judgments. Clearly, the practice in a jurisdiction will affect the 4D attorney's choice of negotiation strategy. Continuing relationships. Perhaps the most important factor in determining a negotiation strategy is the importance of maintaining an ongoing relationship with the opponent. This issue is of particular importance in the child support context for several reasons. First, even with the advent of effective and automatic enforcement mechanisms, the program still depends on voluntary compliance for the majority of its collections. Bad relationships lead to non-compliance. Non-compliance is not cost-effective, regardless of the terms of the order originally negotiated. Furthermore, the outcome of the support enforcement process can have an impact on the relationship between the absent parent and the children. Both of these considerations point in the direction of collaborative negotiation strategies. Negotiating child support and paternity disputes is a very difficult process. Because the payoff structure is limited and the agenda hard to expand, a traditional negotiation strategy might appear the only option. Ethical considerations cut both ways, making it even more difficult to expand the areas for potential agreement. The court system, the federal requirements, the sophistication of the opponents, and the need for a good relationship after the fact all point in favor of the collaborative strategy. Discovery. As noted above, non-attorneys conduct virtually all pre-litigation investigating in 4D cases. However, after an action is filed, more formal discovery devices must be employed by the attorney assigned to the case. This section reviews the general discovery process conducted in most states. Chapter 10 provides additional treatment of discovery in paternity cases. Scope of discovery. Federal Rule of Civil Procedure 26, after which a majority of state discovery rules are patterned, defines the permissible scope of discovery. In general, parties may obtain, through use of one of the discovery devices discussed below, any matter not privileged that is relevant to the subject matter of a pending action. The objective discovery may relate to the claim or defense of any party, including the existence, description, nature, custody, condition and location of any books, documents, or other tangible things and the identity and location of persons having knowledge of any discoverable matter. According to the rule, discovery should be allowed even when the information sought may be inadmissible at trial as long as the information sought is reasonably calculated to lead to the discovery of admissible evidence. Insurance. Subdivisions 2 through 4 of subsection B of the rule discuss three specific applications of the general rule, all of which have potential application to child support cases. Subdivision 2 takes up the issue of the discoverability of insurance agreements. The rule provides for liberal discovery of the existence of insurance which may indemnify or reimburse a party for satisfaction of any judgment entered, but does not affect the general rule that the existence of such insurance is inadmissible in evidence. This matter is clearly of interest to child support attorneys since health insurance may provide coverage for the children and carry out the 4D agency's medical support enforcement responsibilities pursuant to 42 U.S.C. 652 F and 1302 and 45 CFR 306. Trial preparation materials. Federal Rule 26, B3, limits the ability of any party to obtain discovery of documents and tangible things prepared in anticipation of litigation or for trial. The rule codifies and clarifies the U.S. Supreme Court's famous decision in Hickman v. Taylor, 329 U.S. 495, 67 S.Et. 385, 91 Led 451, 1947, which established a limitation on discovery of an attorney's work product. Under both Hickman and the new federal rule, all written materials obtained or prepared by an attorney with an eye toward litigation are free from discovery, except where the other party can justify discovery with a substantial showing that the material is essential to the preparation of his or her case and that an alternative source does not exist. Oral statements made to the attorney or notations of the attorney's impressions and opinions are strictly protected. A written statement, or a transcript thereof, made by the party who is seeking to obtain discovery and in the possession of another party is not immune from discovery. The new federal rule extends the qualified immunity on an attorney's work product to cover written materials obtained in anticipation of litigation by representatives of a party who are not attorneys. Thus, it can be argued that all materials contained in 4D case files, whether obtained prior to or after referral to a 4D attorney, are generally immune from discovery, except for statements made by the party who is seeking the discovery. In addition to the generic discovery limitations, 45 CFR 303.21 requires all states to safeguard information gathered which pertains to applicants for or recipients of support enforcement services, with some stated exceptions. One of the exceptions allows for disclosure of information for purposes directly connected to administration of the 4D program. or other selected programs established by the Social Security Act. Frequently, opposing counsel respond to support enforcement attempts with custody challenges, and seek discovery of information contained in 4D case files to establish a basis for a custody modification. Judges in some states may permit discovery of this information on the theory that it was gathered for purposes directly related to the administration of the Child Support Enforcement Program and therefore is not protected. A state counterpart of Federal Rule 26 would seem to protect against such discovery, and the federal regulations appear to require the 4D agency to attempt to prevent disclosure, despite the counter-argument. Trial experts. Expert witnesses commonly are used in two situations in child support enforcement. The most common is the genetic testing expert employed in contested paternity cases. The other common expert is the economist whom a few states may employ to determine child support levels. There are limits on discovery of facts known and opinions held by experts which are acquired or developed in anticipation of trial, relevant to the subject matter of the action, or reasonably calculated to lead to the discovery of admissible evidence. In most states, a party may serve any other party with interrogatories requiring the latter to identify each person who will be called as an expert witness, to state the subject matter and the substance of the facts and opinions on which the expert is expected to testify, and to provide a summary of the grounds for each opinion. If the expert was retained in anticipation for litigation but is not expected to be called as a witness, the expert's knowledge or opinions is discoverable only upon a showing of exceptional circumstances. The Fifth Amendment. A major limitation to effective discovery devices in child support and paternity litigation is the Fifth Amendment's protection from self-incrimination. The most helpful information to be obtained through discovery concerns the absent parent's financial condition, because this information could well subject the absent parent to conviction for criminal non-support. The Fifth Amendment may prevent compelled discovery. Tennessee Department of Human Services v. Vor. 595 SW2D 62, Tennessee. 1980. Many states will grant immunity to avoid the self-incrimination problem, but the procedure can be so cumbersome as to defeat the purpose of liberal discovery, which is to make the gathering of information an effective and inexpensive aid for trial preparation. Discovery devices. The normal array of discovery mechanisms afforded a litigant by state law includes the following: depositions upon oral examination, depositions upon written questions, written interrogatories, production of documents or things, permission to enter upon land or other property, for inspection and for other purposes, physical and mental examinations, requests for admission. Discovery in child support enforcement litigation is most important in contested paternity cases. Chapter 10 deals with each of the above discovery mechanisms, both in general and as applied to paternity litigation. Both interrogatories and requests for admissions may be served on the adverse party at any time after service of process, and both are very effective methods of narrowing contested issues at trial and obtaining evidence regarding an absent parent's financial situation. Most absent parents are willing to complete a financial statement voluntarily, and this step in the information gathering process often will have been completed before the case is referred for legal action. Nevertheless, it is advisable to have a set of interrogatories available for use in cases where a support order needs to be established, or for use in civil contempt proceedings. Exhibit 4.1 in the appendix to this chapter provides a model for interrogatories. Duty to supplement. Federal Rule 26(e) requires parties to supplement responses, even though they may have been complete when made, in the following instances. The response dealt with persons who have knowledge related to discoverable subject matter or who are to be called as witnesses at trial, or additional persons or witnesses have been identified. The response is no longer true, or new information causes the party no longer to believe the response to have been true when made. If a party fails to comply with the duty to supplement, the court may refuse to allow an unnamed witness to testify, grant a continuance or new trial, or grant other relief which it deems just. Exhibit 4.1 Sample interrogatories to defendant in the District Court of County State of State. Ex rel. Plaintiff. Case number versus defendant. Interrogatories to defendant comes now. The state of the relation of and submits the following interrogatories to the defendant, to be answered fully and in detail by defendant within days. As provided by rule, these are intended as continuing interrogatories, with a duty in defendant to supplement his/her responses. Instructions: type your answers to the following interrogatories in the space provided on this form when possible. If the space provided is not sufficient to answer the interrogatory completely, type your answer on a separate piece of paper and attach it as an appendix hereto, noting on this form which appendix contains your answer to the interrogatory and noting on the appendix a reference to the interrogatory being answered. Upon completion, give proper instruction regarding where and how to send responses. 1. State your full name, the date of your birth, and your present place of residence. 2. Do you live in an apartment or in a private house? 3. If you live in a private house, is it owned by either your spouse or any member of your family or a relative? If so, state when it was bought, for how much, and whose money was used. 4. How many rooms do you occupy? 5. Do you have a lease? 6. What is the name and address of your landlord? Many of the interrogatories included herein have been adapted from Adams et al. A Guide for Judges in Child Support Enforcement, pp. 71-75, Rockville, M.D., National Institute for Child Support Enforcement, 1982. 7. What is the amount of the rent? 8. Who pays the rent? 9. Is the rent paid by cash or by check? 10. Is the rent currently paid? 11. Have you any boarders or subtenants? 12. If so, give their names and the amount of rent paid by each. 13. If the rent or any other bills are paid by check, give the particulars thereof, the name of the drawer of such checks, and the banks on which they are drawn. 14. Are you married? If so, give your spouse's first name and maiden name if appropriate. 15. Have you any children? If so, give their names, ages, and addresses. 16. What is your usual occupation? 17. Are you currently in business or employed? If so, give the name and address of such business or employer. 18. What is your social security number? 19. If you are presently employed, state the particulars of any contract of employment and the amount of salary, commissions, or other compensation that you are to receive and the amount of any arrears thereof. 20. If you are married, please state the date of your marriage, a. the number and names of all dependents for whom you are b. financially responsible. 21. If your spouse or any dependents are employed or in business, give the name and address of such employment or business. 22. If you are not the sole supporter of your family, state the amount of the contribution of each member of your family toward the support of your home. 23. If you are employed or in business, state whether you or any members of your family or other relatives are, or at any time were, proprietors, party owners, stockholders, directors, or officers of any such business. 24. State what business you have conducted and what positions you have held in the last 5 years. 25. If are you an officer, director, or stockholder of any corporation? So, give the details. 26. Is your spouse an officer, director, or stockholder of any corporation? If so, give the details. 27. Do you have, in your own name or jointly, any bank account, commercial savings, or otherwise? If so, state where and the amount of the balance therein. 28. When and where did you last have such a bank account? 29. Do you have power of attorney or other authority to sign checks or other instruments for the payment of money on any bank account? 30. Does your spouse have a bank account? If so, state the name and address of the bank and the amount of the balance therein. 31. State the source of the money in your spouse's bank account. 32. Have you or your spouse a safe deposit box? If not, when did you last have one? 33. Give the name and address of any bank or safe deposit company in which such a safe deposit box is always maintained. 34. Have you the right of access to any safe deposit box? 35. Do you have any accident, health, or life insurance? 36. If so, give a. the name of each company, b. each policy number, c. the amount, type, and date of issuance of each life insurance policy. D. The name and address of the beneficiary of each life insurance policy. E. The date and particulars of any change of beneficiary. And F. The particulars of any assignment or assignments of life insurance policies. 37. Are you receiving or have you any claim for disability payments on any insurance policy? 38. If so, give the name of the company, the number of particulars of the policy, and the amount thereof. 39. If so, is there any fire insurance on the furniture in your home? What is the amount, what is the name of the company issuing it, and in whose name is it issued? 40. Where are the policies of insurance referred to above? 41. If you have borrowed on any life insurance policies, what did you do with the money? 42. Are you a party to any contract of any kind? 43. Are you acting as executor, administrator, trustee, receiver, guardian, or in any other capacity under any will, agreement, or court appointment? If so, give the full particulars thereof. 44. Did you file federal or state income tax returns in the last 3 years? If so, furnish copies of such returns. 45. Do you belong to any organization, club, or union? 46. Has any kind of license, permit, or appointment been issued or granted to you by any federal, state, or city government or agency or department thereof? If so, give the details thereof. 47. Are you entitled to any money from any federal, state, or city government or agency or department thereof? If so, give the details thereof. 48. Does anyone owe you money or goods? If so, give the details thereof. 49. Have you an automobile driver's license or chauffeur's license, and, if so, what car do you drive? 50. Do you or your spouse own or have any interest in any of the following? A. Real estate. B. Stocks, bonds, or other securities. C. Mortgages on real property or personal property. D. Promissory notes, drafts, bills of exchange, or other commercial paper. E. Judgments. F. Jewelry or antiques. G. Stamp collections or coin collections. H. Defense, war savings, or savings bonds. I. Automobile or truck. J. Patents, inventions, trade names, trademarks, or copyrights. K. Joint ventures or other business enterprises. 1. Warehouse receipts, bills of lading, or other documents of title. 51. Do you or your spouse own or have interest in any other property not enumerated above? 52. If you or your spouse own any of the property described in questions 50 and 51, give the full particulars thereof. 53. Have you any securities with any stock brokerage firm? 54. Have you any account with any stockbroker or commodity broker? If so, give the particulars thereof. 55. When did you last have any such account? Give the full particulars thereof. 56. Have you now or did you ever have power of attorney or authority over any other stock, bond, or other security or commodity account? If so, give the full particulars thereof. 57. Have you filed any trade name certificates or partnership certificates? If so, under what name? 58. Are you, at the present time, listed as an heir, legatee, or devisee in any probate estate which is yet to be closed? 59. If your answer to the preceding interrogatory is yes, please list the name of the decedent and the location of the court which has assumed jurisdiction of the matter. 60. If any of your property is mortgaged, pledged, encumbered, or subject to any conditional bill of sale, give the full details and the status thereof. 61. Have you or your spouse any personal property in pawn? If so, give the particulars thereof. 62. Have you applied for a loan from any bank, finance company, or other lending institution in the last 3 years? If so, what disposition was made of such application? 63. If have you ever made an assignment for the benefit of creditors? So, when and in what court? 64. Has a receiver of your property been appointed by any court? 65. Are there any outstanding executions, orders, or subpoenas in supplementary proceedings, garnishment executions, or orders for payment of money in supplementary proceedings under any other judgment against you? If so, give the particulars thereof. 66. Please, what are your average monthly expenses and how are they met? Itemize. 67. Are you making payments to any creditor? Details thereof. If so, give the full. 68. What is the total of your liabilities, exclusive of child support, and what are the names and addresses of your creditors? 69. When and for what purposes were these liabilities incurred? 70. What information can you give us regarding the other parties to any liabilities you have? 71. Are any of the other parties involved in any branch of the military service to the United States? 72. Are you unable to pay your debts? 73. Are you willing to be adjudged bankrupt? 74. What books and records do you keep showing your receipts and disbursements? 75. Within the past year, have you received any payments of money other than as already described? If so, state when and the amounts, give the particulars of any checks received, and state what was done with the money. 76. Have you assigned any cause of action, judgment, insurance policy, salary, income, or disability payments? 77. Have you transferred or sold any other property within the past 5 years? If so, describe the property and give the full details of any such transfer, including the names and addresses of the people you transferred the property to, when the transfer was made, and the amount given to you in exchange for the property. Respectfully submitted, Attorney for Plaintiff.